Well, Jay raised a lot of issues there, which I think that you will take issue with,
Oh,
Steve.
yes.
So why don't you have at it?
Okay, so first, Jay, I guess I have a question for you. So do you think that the filtration test is the right test, or the selection and arrangement test is the right test for literary works?
I think they're both right. I think the filtration's important. Of course, it developed out of computer software cases where jurors had no clue how to analyze similarity between two source code programs.
What does that mean, Jay, filtration?
Filtration. Well, that means that they filter out the unprotectable material and compare the remaining golden nuggets of similar expression. And so I think that's important to do because of this, I think, something that's a fundamental interest of this country is freedom of speech, freedom of expression, freedom of ideas, and not crippling authors from building on others' ideas, as I said before. So I think filtration is really important, but the risk that it provides is the one that Steve is sensitive to, which is that it can risk a court losing fact of the fact that if in some limited cases a compilation of elements that aren't themselves protectable, maybe they're too abstract, might be an original work in itself. And so I think most courts actually, at least outside the computer area, I think most courts, and again, I don't have the data, I haven't sat down and made charts about these cases, but most of them, I think, are aware of this problem. And they filter, but then they go, then we have to consider whether there's like a selection, ordering, and arrangement problem. And in most of these cases, the ones we'll focus on today, they basically, where they deal with it, they rule it out. So.
Yeah, well, actually, they don't apply the selection and arrangement test. So the selection and arrangement test has been around in one form or another, actually, for many years. The courts were using it as early as 1947 in the Universal Pictures versus Harold Lloyd Corp case. The citation, for those who are taking notes, is 162 F. 2nd 354. It's a Ninth Circuit case from 1947. So the selection and arrangement test has been around for quite a while, whether they were calling it the selection and arrangement test or not, because courts recognized that if they did filter out all the quote-unquote unprotectable elements, that typically there would be, at the end of the day, nothing left. And so only by looking at a combination of unprotectable elements was there any chance that a plaintiff could win in any of these cases. Because everything's been done before. Everything's been done going back to Shakespeare and before Greek tragedies. So all people are doing now is just rearranging elements that have already been in existence. I mean, no one's really coming up with anything new. And so the court, in our amicus brief, which I thought was part of the materials that we filed in support of the Walk of Shame case, which is Chuck's case, we actually list all the cases in the Ninth Circuit that have applied the selection and arrangement test. And it's quite a few. And they've applied it in screenplay situations, such as the Miller versus Miramax case, which involved Shakespeare in Love. They've, as early as late as 2012, they've applied the selection and arrangement test in the LA Printex case, which was a fabric design case. They always apply it in the in music cases. Dillon versus NBC, which was a lower court case from 2013, applied the selection and arrangement test. So Metcalf versus Bochco applied the selection and arrangement test. So what you see is that really the courts are just confused, if you will. They apply the right test, the selection and arrangement test, sometimes, and then sometimes they just don't. And when they don't, as they didn't in, for example, the two cases which are in the materials from Stephen Wilson, the Frozen case and the New Girl case, or the case that's in the materials, should be in the materials, from Judge Morrow, the Walk of Shame case, they just find a way to distinguish it. So in the New Girl case, for example, Judge Wilson just says, oh, there aren't as many similarities here as there are in Metcalf versus Bochco. Well, guess what? That's not true. Danny Lifshitz, who's here today, has done comparisons of a lot of other cases, has actually done the graph where he takes Metcalf versus Bojko, and he lists all the elements, and then he puts other cases, such as Funky Films and other cases, and is able to show that there's the exact same amount of similarities, and the quality of the similarities is exactly the same. It's just become completely arbitrary. The judges just do whatever they want. If you get Judge Wilson, dismiss your case. You have no shot of winning. On the other hand, if you get Christina Snyder or some other good judges, who do we have on the purge? Fitzgerald. If you get Fitzgerald, if you get some other fair judges, you have a shot at actually perhaps getting past a motion to dismiss or a motion for summary judgment. That is the generally prevailing consensus now. You can talk to Glenn Kulik, you can talk to anybody. They will tell you it purely depends now on which judge you get, because it is completely arbitrary. They basically, if they want to, they find a way to distinguish Metcalf and not apply the selection and arrangement test. Judge Morrow, what was her excuse in the Walk of Shame case? She said, oh, it only applies when there's literal similarity or something like that. So they distinguish it when they want to. The law is in complete disarray. Bottom line is, if you're a plaintiff, you have it's a long shot at winning. And now, also, if we're talking about trends, we just had a case come down, just published by the California courts on April 22nd, called Ryder versus Lightstorm. It's the last of the Avatar cases, and it's a horrible case. My firm has filed a petition for review by the California Supreme Court. We literally just filed that yesterday. And if that case stands, what they tried to do there is graft on the substantial similarity filtration tests onto idea theft claims, which were our only hope. Before then was that we still had idea theft claims. If you read Death of Copyright or Death of Copyright 2, you know that my articles, you know that idea theft claims are sort of the only still viable means for a plaintiff to win one of these cases. And in those cases, you basically have to have a direct submission from the author to the company. If you don't have that, then you don't have an idea theft case. And so in light of the Ryder case versus Lightstorm, which was just published within the last 2 weeks, the studios have now been able to finally. They were trying to say that the idea theft claims were preempted, and they lost that in 2011 on the Muntz versus Pilgrim Films case. They were really hoping that that was going to work. Didn't work, and so now they finally succeeded with this Ryder versus Lightstorm, basically for all intents and purposes applying the filtration test to idea cases, and so now. Barring a situation where the California Supreme Court takes this up for review, it's actually going to be really tough for people to win idea theft cases as well.